Hello, dear friends. Welcome back in our YouTube channel IndusLex. It is a official YouTube channel of IndusLex Foundation. And today again we are trying to discuss that how a man can protect himself, how a man can defend himself in a false case if registered against him. Dear friends, there are steps and the manner in which you can protect yourself. Suppose that a false FIR is registered against you, have the very first remedy against that false FIR is a criminal writ. You may approach the competent jurisdiction of your high courts, whichever states you are living. You approach your high court under Article 226 of the Constitution of India and challenge that FIR on the basis that on that FIR is a sheer abuse of the process of law, or if the contents of FIR which is enumerated in the FIR is not disclosing any cognizable offense, commission of cognizable offense, then you have a right that the FIR must be quashed by the Honorable Court. The law laid down under for the questing of FIR is Bhajan Lal versus State of Haryana, in which Honorable Apex Court held that an FIR can be quashed when, after reading the first contents of the first information report, if no cognizable offense is disclosed, then it can be quashed by the Honorable Court. And further additional ground is that maybe on reading the contents of the FIR, there is allegation which shows the commission of cognizable offense. But if you prove your case that this FIR is a result of a civil dispute or a abuse of process of law, then Honorable Court may, if admit your submission, can quash the first information report. This criminal writ jurisdiction is extraordinary jurisdiction and it is not governed by the Criminal Procedure Code or a Bharati Nagrik Suraksha Sanhita. This is a constitutional remedy provided to every citizen that he may approach the Honorable High Court and challenge the false FIR which is registered against him or her, as the case may be. And suppose that if you are not able to get that quashing of that FIR, then you have another remedy provided under the Criminal Procedure Code or Bharati Nagrik Suraksha Sanhita. That remedy is anticipatory bail. You may approach the district court and file the application for the anticipatory bail. In the anticipatory bail application, you have to show the apprehension of arrest. And at this stage, you have to carefully examine the contents of the FIR and the section under which FIR is registered. Because after the year 2021, in the light of the Honorable Supreme Court judgment, namely Satyendra Kumar Antil versus CBI, Honorable Supreme Court reiterated the another judgment of the Honorable Supreme Court in the Arnesh Kumar versus State of Bihar, that if the offense is punishable below the 7 years, then police officer is not shall not arrest the person at the first instance. He has to give him notice that his or her name is bring in the particular case, and he has to reply about his version, and then police officer record his statement and submitted the charge sheet, and along with the charge sheet, there is no need to send accused or present accused before the magistrate in the light of Siddharth versus State of Uttar Pradesh judgment. So, if the FIR is registered under such section, which is punishable not more than 7 years, then police is not going to arrest. Then you have a remedy that you can't apply for anticipatory bail because police is not going to arrest you. So if the offense is below 7 year, your first remedy is to challenge the FIR, and if the FIR you will not get succeed in the quashing of FIR, you will get the direction in the light of Arnesh Kumar versus State of Bihar that the police will not arrest you till the submission of charge sheet and give you the notice to appear before him and participate in the investigation. Now, then if the police after some giving you a notice and you appear before the police station and recorded your statement, and then police submitted its charge sheet in the court of magistrate or the session court, in the session court as the case may be, then on that final report on that charge sheet, magistrate took cognizance and summoned the named accused. When the court summoned the accused in the below 7 year offense, then this time again you challenge the charge sheet and along with entire criminal proceeding along with cognizance and summoning order. Here, you have to understand that at the initial stage, you challenge only the FIR, and once you got protected at the stage of registration of FIR to the submission of final report, then the police submitted its report in the court, and now it is the court domain whether he he would send you in jail or he would grant you the bail. And again, in this situation, Satyendra Kumar Antil versus CBI judgment is there, in which Honorable Supreme Court issue guidelines to the trial court that if the offense is punishable with less than 7 years of imprisonment, interim bail must be granted and the final disposal would be on merit. So, if the offense is below 7 years, you may again approach the Honorable High Court under Section 482 CRPC or 528 Bharatiya Nagrik Suraksha Sanhita challenging the entire proceeding. And if this time Honorable Court satisfied with the submission of the counsel that the present matter is not disclosing any commission of cognizable offense, or it court may satisfy that there is a sheer abuse of the process of law, this criminal proceeding is used as a tool to harass the accused, then honorable court may quash the entire proceeding. And if the honorable court not quash the on your proceeding, then you at least get the remedy that you may move your discharge application through the counsel in the trial court. So without trying, the main purpose is that you must not take the bail in the court. However, it doesn't matter how much easy to get bail in those offenses which are punishable less than 7 years. It is because you have a remedy till you may file the discharge application. And why the discharge application? This stage is very important before the framing of charge. At the stage of discharge, court is duty bound to record your defense also, and after considering the defense of the accused and the charge sheet submitted before him, after the perusal of charge sheet and the submission in the discharge application. If the trial court deem fit, he may discharge the accused at that very stage, or if he not discharged, you have another right to challenge this rejection order of the discharge application in the criminal revisional jurisdiction in the Honorable High Court. So be careful that if even if the offense is punishable below the 7 years, you have first remedy that you may approach the Honorable High Court under Article 226 of the Constitution of India, challenging the FIR. And if the F and if after the submission of charge sheet, you may approach Honorable High Court for quashing of entire proceeding along with the charge sheet and the summoning order. And even if at this stage you not able to get succeeded in quashing of the charge sheet, you may got the permission from the Honorable High Court that direct the accused that and give the liberty to the accused that he may approach the session court or the trial court and may file the discharge application through the counsel. It is also a big relief because to move the discharge application, you have to surrender before the court and secure the bail. But when you get the direction from the Honorable High Court that whenever I will permit the accused to move the discharge application through the counsel, and then if the you are not discharged by the trial court, then you may again challenge the entire proceeding and the discharge order in the criminal revision before the Honorable High Court. So this is the case where the offense is below 7 years. But when offense is punishable more than 7 years, you have to firstly challenge the FIR, and if you get succeeded on getting the no coercive measure or arrest till the no arrest till the submission of charge sheet, it is a big relief for the accused. But even if the FIR is not quashed or stayed by the Honorable High Court, then he has another option to get anticipatory bail, because where the offense is punishable below the more than 7 years of imprisonment, then there is direct apprehension that the police is going to arrest him as he appear before the police for giving his statement. Therefore, you may file anticipatory bail application. And if you get the anticipatory bail for till the submission of charge sheet or till the submission of trial, it doesn't matter. Whenever the charge sheet is filed in the court below, then again you may challenge the entire proceeding, and maybe this time you get succeeded on getting the stay or a questioning of your criminal case. And even if at this stage you are not able to secure the quashing of the charge sheet, again you try to get at least a direction that if you not avail the anticipatory bail jurisdiction, or if you not get not take the anticipatory bail in the trial court, then you may get direction that you may file the discharge application through the counsel. So first stage of the case is registration of FIR, second is submission of charge sheet, and third is moving the application discharge application in the trial court and then challenge that rejection order of the discharge application in the criminal revisional jurisdiction in the high court, or maybe in the district before the district judge, as the case may be. If the discharge application is filed in before the magistrate court, that the revisional court is the district judge court, and if the additional district judge or district judge passed the order of discharge rejection, then the revisional court would be the Honorable High Court. And even if the case is triable by the magistrate court, the revisional court is the district judge court. And after availing the exhausting the remedy of criminal revision, you may approach the honorable court in extraordinary jurisdiction under section 482 CRPC or 528 BNSS, as the case may be. In this way, you firstly ensure that whatever the case you have is all come in the record of the honorable high court and the trial court till the submission, till your disposal of the application, discharge application before the district judge or the trial court, as the case may be. In this manner, you may protect yourself from the false case. And the another remedy is left with the honorable supreme court. Suppose that you are sure confident that your FIR must be quashed, but honorable high court not inclined to interfere with the registration of FIR, then your dismissal of your criminal writ may challenge before the Honorable High Court. On the second occasion, when you file the quashing of charge sheet, and if it is not done by the Honorable High Court, you may approach the Honorable Supreme Court. And even if the discharge application is rejected by the trial court and you move an application before the High Court, and High Court is not inclined to interfere with the trial, then you may also approach this time to before the honorable supreme court and tell the matter before before the charge, before the rejection of your discharge application, and before availing the remedy of criminal revision in the honorable high court, it is not justifiable or not a good idea to surrender before the court below and get the bail, because once you get the bail, you are duty bound to follow and face the trial. And the facing the trial is something very hectic and very painful, and it may be something like that you should not face very a consequential very bad thing. The trial criminal case is something like a cancer. Once you trapped into the trial, it consume lots of time, and what and there is no certainty that you get convicted beyond reasonable doubt, because the principles of the beyond reasonable doubt is may be ignored by the trial court at the time of pronouncement of the judgment. So the good idea is that if you can afford, you must challenge the FIR, then must challenge the charge sheet, and then must challenge the discharge rejection order before the High Court. And if 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 the accused can afford, he may approach the Honorable Supreme Court. Thank you.